Hello everybody. Today we would be discussing the module on the introduction to the Marrakesh Agreement establishing the WTO. I would be presenting this module on behalf of Mr. Deepak Raju. Understand the introduction of the Marrakesh Agreement and the organizational structure of the WTO, which is the key decision making bodies. The aims and objectives of the WTO as reflected in the preamble and the Marrakesh Agreement would also be discussed. Hence, this module would understand the organizational structure of the WTO, the key decision making forums in the WTO, the objects and purposes of the WTO as set out in the Marrakesh Agreement, and how the WTO agreements give effect to these objects and purposes. This module would cover the organizational structure of the WTO. We would understand the WTO Ministerial Conference, the General Council meeting as dispute settlement body, the General Council meeting as a trade policy review body, the Council for Trade and Goods or the Goods Council, the Council for Trade related aspects of intellectual property rights or the TRIPS Council, and the Council for Trade in Services. Thereapart, the aims and objectives of the WTO as reflected in the preamble and the Marrakesh Agreement would also be understood with the help of the creation of a common institutional framework for the conduct of trade relations. It would understand the forum for negotiations, the development goals, the optimal use of the world's resources, and the sustainable development and preservation of environment. The learning objectives of this module are that international law at its inception was often referred to as a law of nations, reflecting an understanding that the legal system concerned solely the conduct of nations or states. In other words, historically, states were considered to be the only subjects of international law. It was solely the action of states that created the norms of international law, and it was solely the action of states that was governed by the international law. However, in recent times, this understanding has evolved, and it is now widely accepted that a wide range of entities apart from states can be subjects of international law. The first among these new categories of actors to be recognized as subjects of international law was international organizations. In 1949, the International Court of Justice was called upon to render an advisory opinion as to whether the United Nations had a legal personality of its own, independent of the legal personalities of its member states. The court understood an examination of the United Nations Charter and the powers and functions vested in the organization under the Charter. The court concluded that the members had vested on the United Nations powers and functions that could be performed effectively only if the organization had its own legal personality. While studying any international organization, the constituent instrument, usually an international treaty that establishes the organization, is often the best starting point. The same is true of the World Trade Organization. The efforts at establishing a multilateral normative framework for international trade predates the Marrakesh Agreement by nearly half a century. The failed attempt at the Bretton Woods Conference to establish an international trade organization and the decades of provisional application of the General Agreement on Tariffs and Trade are certainly important areas for exploration for any student of the multilateral trade system. Yet, the Marrakesh Agreement forms a watershed moment in the history of the multilateral trade framework. For one, the Marrakesh Agreement contained in its annexes several substantive agreements, either explorating the GATT discipline or imposing additional commitments on its members. However, more importantly, for the purposes of this chapter, it was through the Marrakesh Agreement that the multilateral trade framework attained the forum of an international organization. In addition to establishing the organization, the agreement lays down several detailed rules for the functioning of the organization, including the decision-making processes within the organization. The organization, as well as all the bodies and functionaries of the organization, derive their powers and functions from the agreement. Also, the preamble to the Marrakesh Agreement elaborates the key objectives of the WTO as an organization, which is a valuable tool in interpreting and understanding the substantive provisions of both the Marrakesh Agreement as well as the other multilateral trade agreements in the WTO framework. The chapter then seeks to introduce the reader to the organizational structure of the WTO, the key decision-making bodies, as well as the decision-making process in the WTO as established by the Marrakesh Agreement. Additionally, the readers will be introduced to the aims and objectives of the WTO as expressed in the preamble to the Marrakesh Agreement and the substantive provisions in various substantive agreements that seek to give effect to these aims and objectives. Now we would understand the organizational structure of the WTO and the key decision-making bodies. The Marrakesh Agreement establishes several bodies within the WTO institutional framework. All of them act as important forums for decision-making on matters covered by the organization. Below is an organizational chart available on the WTO website. As can be seen, the institutional framework is complex and includes several committees, working parties, etc. In line with the introductory nature of this chapter, detailed discussion shall be limited to some key decision-making bodies, namely the Ministerial Conference, the General Council, the Dispute Settlement Body and the Trade Policy Review Body. Now we would understand the WTO Ministerial Conference. The WTO Ministerial Conference, set up under Article 4 Clause 1 of the Marrakesh Agreement, establishing the WTO, is the highest decision-making body of the WTO. It is comprised of all the member countries and customs union of the WTO. The Ministerial Conference meets at least once in every 2 years. The ambit of decision-making power of the Ministerial Conference is wide enough to include matters under any multilateral trade agreement on the request of a member. There has been 9 ministerial conferences till date. Ministerial Conference is also assigned the function of establishing the mandatory committees, which are committees on trade and development, a committee on balance of payment restrictions, and a committee on budget, finance and administration, and such other committees as it may be deemed fit. The Ministerial Conference appoints the Director General of the WTO Secretariat and adopts regulation laying down the powers, functions, terms of service, etc. of the Director General. The decisions at the Ministerial Conference are made according to the majority of the votes cast, with each member having 1 vote unless an exception has been provided for in the Marrakesh Agreement or the relevant multilateral trade agreement. The Ministerial Conference, along with the General Council, holds the exclusive authority to adopt the interpretations of the Marrakesh Agreement as well as other multilateral trade agreements by a 3/4 majority of the members' votes. It also has the power to waive an obligation imposed on a member state by a multilateral treaty under exceptional circumstances and to review such waiver annually until it is terminated. It also has powers with respect to amendment of the Marrakesh Agreement, accession to the agreement, etc. The 8th Multilateral Conference of the WTO at Geneva approved the accessions of Russia, Samoa and Montenegro. It also adopted a waiver to enable developing and developed country members to provide preferential treatment to services and services supplier of least developed country members. The 9th Ministerial Conference at Bali saw the adoption of the Trade Facilitation Agreement, which is aimed at significant reduction in transaction costs in international transactions. Now we would understand the General Council. The role of the General Council is that the General Council established under Article 4 Para 2 of the Marrakesh Agreement is the decision-making authority of the WTO that meets regularly to carry out the functions of the Ministerial Conference that meets only once in 2 years. The members of the General Council are the representatives of the member states of the WTO. It approves the rules and procedure governing the functioning of the various committees established by the Ministerial Conference. It facilitates cooperation between the WTO and other intergovernmental and non-governmental organizations that perform functions that linked to that of the WTO. It approves the annual budget of the WTO. The decision-making process is similar to that at the Ministerial Conference and is made according to the majority of the vote cast, with each member having 1 vote, unless an exception has been provided for in the Marrakesh Agreement or the relevant multilateral trade agreements. As mentioned under the heading on Ministerial Conference, the General Council, along with the Ministerial Conference, adopts the interpretation of the Marrakesh Agreement and the multilateral trade agreements on a 3/4 majority vote. The General Council also convenes as the dispute settlement body and the trade policy review body. We would understand the meeting of the General Council as the dispute settlement body. The General Council meets as a dispute settlement body in order to perform the functions under the WTO dispute settlement undertaking adopted at the Uruguay rounds of negotiations. It consists of representatives of all member states. The DSB has its own chairman and lays down its own procedures for the conduct of its business. The DSB has the authority to establish panels, adopt panel and appellate body reports, maintain surveillance of implementation of rulings and recommendations, and authorize suspension of concessions and other obligations under the covered agreements. When DSB considers a dispute, only such members who are party to the plurilateral agreement under which the dispute has arisen can cast a vote on that matter. The DSB informs the councils and committees of the WTO regarding developments with respect to any dispute. The decisions of the DSB are taken by consensus. The panels constituted under the DSB in each case assist the DSB in decision making through its appreciation of facts and law after consultations with the parties to the dispute. Once the panel has made its report, the report is circulated among the members. The members have then 20 days to consider the report. The parties who object the panel report can raise the same up to 10 days before the DSB meeting. The report is adopted within 60 days of circulation to the members unless one of the parties to the dispute informs the DSB of its decision to the panel, in which case the adoption is kept on hold till the decision on the appeal is made or the report is unanimously rejected by the DSB. The DSB also constitutes the appellate body consisting of 7 members who are individuals with recognized standing in law and international trade and not affiliated to any government, and 3 of whom shall serve on each case. Each member has a term of 4 years. It hears appeals from panel cases. The appeals are to be decided within 60 days from the date on which the party signifies his decision to appeal. When the appellate body is unavailable to deliver its decision within 60 days, it has to inform the DSB with the reasons for the same in writing. In any case, the maximum time frame for deciding an appeal cannot exceed 90 days. Appeals can only be from questions of law in the panel report. The outcome of an appeal may be the appellate body upholding, modifying or reversing the conclusions of the panel. This reporting shall be wholly and unconditionally adopted by the DSB and will be binding on the parties unless there is a unanimous decision of the DSB to reject the same. Generally, the maximum time between DSB constituting the panel and considering the panel report, appellate body report as the case may be, cannot exceed 9 months where the panel report is not appealed and 12 months where the panel report is appealed. Now we would understand the meeting of the General Council as the trade policy review body. As provided under Article 4, Para 4 of the Marrakesh Agreement, the General Council meets as a trade policy review body or the TPRB to perform its functions under the trade policy review mechanism. The body has its own chairman and lays down its own procedure. The body reviews the trade policy of each member country and the impact of such policy on the multilateral trading system on a periodical basis. The frequency of the review on each member depends on the share of such member in the world trade. The review is conducted on the basis of the report provided by the member who is subjected to review, another report that is prepared by the WTO Secretariat on the basis of the report furnished by the member country after taking clarifications from that country. Once the review is complete, the TPRB publishes the report furnished by the member country, the report by the WTO Secretariat and the minutes of the review meeting of the TPRB, and the same is also forwarded to the ministerial conference. The TPRB is also responsible for the preparation of an annual overview of the developments in the international trading environment. The Council for Trade in Goods or the Goods Council. The Council for Trade in Goods or the Goods Council, established under paragraph 5 of Article 4 of the Marrakesh Agreement, looks into implementation of the General Agreement on Trade and Tariff, which is the law on the international trade in goods. It functions under the guidance of the General Council. The members of the Goods Council are representatives of the member states. The Goods Council is comprised of 10 committees, each dealing with a specific subject. These committees are the committees on agriculture, anti-dumping, market access, sanitary and phytosanitary measures, technical barriers to trade, subsidies and countervailing measures, customs valuation, rules of origin, import licensing, trade-related investment measures and safeguards. The committees shall establish their respective rules of procedures subject to the approval of the Goods Council. The Council for Trade-related Aspects of Intellectual Property Rights or the TRIPS Council. The Council for the Trade-related Aspects of Intellectual Property Rights or the TRIPS Council, established under paragraph 5 of Article 4 of the Marrakesh Agreement, oversees the implementation of the TRIPS Agreement. The Council is under the general guidance of the General Council. It is established subsidiary bodies for the performance of its functions. Its members are the member states of the WTO. Article 68 of the TRIPS lays down the functions of the TRIPS Council to include monitoring of the member countries' compliance with the TRIPS and providing consultations to members on matters relating to the TRIPS. The Council for Trade and Services. The Council for Trade and Services is provided for in Article 4, paragraph 5 of the Marrakesh Agreement along with the Goods Council and the TRIPS Council. It functions under the guidance of the General Council. The members include representatives of all member states. Article 24 of the GATS provides the functions of the Council. The Council provides consultations to the members with respect to the unresolved issues relating to trade and services. The members of the Council consist of the members of the WTO. Now we would understand the aims and objectives of the WTO as reflected in the preamble and the Marrakesh Agreement. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Given this cardinal norm of treaty interpretation, it is important to understand the objects and purposes of the treaty parties sought to attain through the treaty. Often the provisions of the treaty themselves as well as the preamble of the treaty provide useful indications of these objects and purposes. In case of the Marrakesh Agreement, the preamble as well as Article 2 and 3 spell out these objects and purposes. Some of the key objects and purposes emerging from these provisions and the preamble as how these objectives are sought to be attained through various substantive WTO agreements is discussed below. Article 31, Clause 1 of the Vienna Convention on the Law of Treaties 1969. Now we will understand the creation of a common institutional framework for the conduct of trade relations. Article 2, Clause 1 of the Marrakesh Agreement, while listing the function of the WTO states, the WTO shall provide the common institutional framework for the conduct of trade relations amongst its members in matters relating to the agreements and associated legal instruments included in the annexes to this agreement. Countries have engaged in negotiation with each other over matters of international commerce for millennia. Yet, these negotiations were often bilateral or involved a limited number of states. Moreover, these agreements seldom created institutional frameworks to ensure their smooth implementation, particularly at times when political relationships between the parties to the agreements went through rough patches. The GATT 1947 certainly provided an improvement over the status quo of its time. GATT as an international treaty imposed binding legal obligations upon the contracting parties which they were expected to honor independent of political circumstances. Moreover, the contracting parties acted collectively could take important decisions regarding the functioning of the organization and could exercise a limited supervisory role to monitor the implementation of the GATT commitments. Yet, the lack of real organization with a well adapted institutional framework meant that the same rudimentary institutional structure would have to deal with all diverse aspects of international trade. Also, this meant that much of the decision making as well as the efficacy of the supervisory functions was dependent on political consensus rather than legal norms. It is against this background that Article 2, Clause 1 of the Marrakesh Agreement envisions WTO as a common institutional framework. As a first step towards meeting this end, Article 1 establishes the World Trade Organization and Article 8, Clause 1 clarifies that it has independent legal personality, implying that the WTO is capable of holding rights and obligations independent of those of its members. Further, as discussed above, the Marrakesh Agreement and other multilateral trade agreements establish several specialized bodies for decision making and monitoring of implementation of commitments in various aspects of international trade. Article 2, Clause 2 of the Marrakesh Agreement states, The WTO shall provide the forum for negotiation among the members concerning their multilateral trade negotiation in matters dealt with under the agreements in the annexes to the agreement. The WTO may also provide a forum for further negotiation among its members concerning their multilateral trade negotiation and a framework for the implementation of the results of such negotiations as may be decided by the ministerial conference. The Marrakesh Agreement and the WTO themselves are results of prolonged negotiation among a large number of participants. Countries with diverse trade related interests negotiated on several aspects before the draft of the Marrakesh Agreement and other multilateral trade agreements could be finalized. Subsequently, the WTO membership has engaged in negotiations on a large number of topics. While a part of these negotiations concern implementation of existing commitments under negotiations, have sought the adoption of additional commitments. Another important function of the negotiation in the WTO is clarification or elaboration of the existing rules. An example of negotiation concerning implementation of existing commitments is in the area of elimination of agricultural subsidies, an issue that developing countries have repeatedly raised during trade negotiation. The recent efforts at negotiating a trade facilitation agreement is an example of negotiation intending at adoption of additional commitments. The Doha Declaration on TRIPS and Public Health was the negotiated outcome, which was largely the nature of clarifying, quantifying and elaborating existing commitments under the WTO commitments on intellectual property. The WTO as an organization and its members also engage in prolonged negotiations with non-members on conditions for their accession to the organization. These negotiations decide the extent of tariff bindings, service schedules and other commitments that the new entrant undertakes as a part of its WTO commitments. Also, these negotiations often focus on reforming certain laws and institutional structures within the potential member that the existing membership views to be inconsistent with the WTO commitments. It is also open to the existing membership to modify certain obligations, particularly implementation timelines, for the potential member through the clauses in the accession protocol. For instance, Article 28 of the Agreement on Subsidies and Countervailing Measures allows WTO members a 3-year time period to eliminate certain existing subsidies which are inconsistent with the WTO subsidies discipline. Yet the accession protocols of Russia and China effectively deny those new entrants the benefit of the said grace period. Trade negotiations have always been and still remain a political process. The establishment of the WTO as a forum for negotiation does not change that or eliminate all the difficulties associated with the political process of negotiation. Yet, in providing a forum where the views of all the members can be expressed and by providing a common language for negotiation, WTO does take the process a step further. Now we will understand the development goals of the WTO. Smith and Ricardo provided economic evidence to suggest that trade benefits both parties to it. In simple terms, Smith and Ricardo suggest that countries would benefit if they produce what they could produce at lower cost than other countries, exported these goods to other countries and imported what goods that other countries could produce at a lower cost. While economic literature, both in support of trade and against it, have moved to higher levels of complexity on this point. WTO is founded on the assumption that trade benefits all trading partners. Yet it was recognized that simple emphasis should be given to the development needs of least developed nations and other developing countries, and special efforts should be made to meet these ends. For this purpose, the preamble of the Marrakesh Agreement states that recognizing that the relations in the field of trade and economic endeavor should be conducted with a view to raising standards of living, assuring full employment and a large and steadily growing volume of real income and effective demand, and expanding the production of and trade in goods and services while allowing for the optimal use of the world's resources in accordance with the objective of sustainable development, seeking both to protect and preserve the environment and to enhance their means of doing so in a manner consistent with the respective needs and concerns at different levels of economic development. The multilateral trade agreement sought to give effect to these goals through several provisions directed at ensuring special and differential treatment of developing countries. Part 4 of the GATT contains several provisions seeking to address the special needs of developing countries by calling upon developed countries to enhance the market access for developing country products without the expectation of reciprocity. Additionally, in 1979, the GATT contracting parties adopted the enabling clause, which clarified that the most favored nation principle under Article 1 of the GATT did not prevent developed countries from extending additional benefits to developing countries through a generalized system of preferences. Also, several substantive agreements allowed developing countries additional time to implement the commitments. Despite these, several scholars argued that the WTO's outlawing of protectionist tactics like quantitative restriction, voluntary export restrictions, export subsidies and domestic content subsidies, stringent intellectual property norms will deprive the developing countries from availing the same path that several developed countries adopted in their journey towards the present stage of development, kicking away the ladder. What are the optimal uses of the world's resources? As evident from the portion of the preamble of the Marrakesh Agreement quoted above, optimal use of the world's resources is among the proposed objectives of the WTO. There exist concerns that the lure of additional revenues from trade will result in overexploitation of certain exhaustible resources. As a partial solution, Article 20 Clause G of the GATT allows measures relating to the conservation of exhaustible natural resources as an exception to the GATT commitments. The appellate body has clarified that the expression exhaustible natural resources must be given a broad interpretation in line with the objective of sustainable development. Accordingly, even measures taken to protect living creatures has been held to fall under the ambit of this provision. However, Article 20G is available in an exception only if such measures are made effective in conjunction with restrictions on domestic production or consumption. Therefore, it may not be available as a justification where a member chooses to allot a particular commodity solely for domestic purposes, even if that country determines for itself that the measure is in most optimum use of the said resource. In China raw materials, China argued that its ban on certain raw materials was justified since China deemed to make this as an optimal use of the resource. However, the same was rejected by the panel. Here, there seems to be a divergence between multilateral trade framework on the one hand and customary international law, which recognizes the permanent sovereignty of countries over their natural resources and by implication of their rights to determine what uses of natural resources are optimal. Now we will understand the sustainable development and preservation of environment. The preamble of the Marrakesh Agreement also highlights environmental goals and sustainable development among the objects and purposes of the organization. However, the substantive provisions of the multilateral agreements do not create any environmental obligations for the parties. Rather, they often provide exceptions to ensure that trade commitments do not come in the way of environmental goals of the members. For instance, Article 20 of the GATT contains the following exceptions: necessary to protect public morals, necessary to protect human, animal or plant life or health, or for instance, relating to the conservation of exhaustible natural resources. These exceptions have been used to justify measures taken to inter alia, protect clean air, conserve marine mammals, and prevent accumulation of waste tires. Recently, the appellate body has also held that prevention of animal cruelty can fall within public morals under Article 20A while deciding a dispute relating to trade in seal products. India recently banned the import of fear gas based on cruelty to geese. Thank you.